Thank you, Your Honor.
You're welcome. All right, now, at the jail, we have John D. Davis. Are you John D. Davis, sir? Mr. Davis, I'm Judge Capper at Orange County Municipal Court. This is your arraignment period. You have a right to remain silent. You don't have to make statements. If you choose to make statements, they are being recorded and to be used against you. You have a right to have an attorney and to have one appointed if you can't afford one. You have a right to bail and to make the state prove any charge beyond a reasonable doubt. Do you understand those rights?
Yes, sir.
I'm going to go over the charge with you now. It's a domestic violence charge, and it alleges that on December 28th of 2022, so it's been a while, that in the village of South Point, you knowingly caused or tried to cause physical harm to Trista Brown, and that she's either a member of your family or a member of your household. So that's why it's a domestic violence charge. It carries a maximum penalty, 6 months in jail, $1,000 fine. You understand the charge? And you understand the rights you have as a defendant?
Yes, sir.
How do you plead to this charge?
Not guilty, sir.
Do you want a lawyer appointed to represent you?
Please.
Do you have a job?
No, I like how
You don't have any income coming in now?
not like how
I'll appoint Attorney Roger Smith to represent you. Mr. Smith is here in the courtroom now, so he's heard this. I'm entering a not guilty plea. State's position on bond.
I'd like to know if Trista Brown is here. So we
Trista
don't
Brown.
have the benefit of her input at this point. It has been quite some time since this happened, so we haven't gotten any other reports that there have been problems. But we would not oppose an OR bond if there's a protection order. I guess we'd have to have a discussion about whether they need to be together at this point.
Mr. Davis, are you living separate from Trista Brown, or you live under the same roof with her?
separate, sir.
Okay, so it's not a problem for you to stay away.
Right.
Okay, so I'm going to let you out on your own signature, but I'm going to order that you stay away from Trista. Don't go around her, don't contact her, don't post things about her. That's something you can do, right?
Yes, sir.
And then we're going to come back, and I'm going to decide with your lawyer what date we're going to come back for your next hearing. What's your schedule, Mr. Smith?
Judge, I'm here every Friday in June. I can look for Monday dates if we need to.
How about the 30th then?
Yes, I'm here.
Okay, Mr. Davis, I'm setting your next hearing for June 30th, so that's the last Friday in June. You got to be at the court in Chesapeake. You know where that is?
Yes, sir.
June 30th at 10 a.m. Do you have a cell number you want to give so Mr. Smith can have it to try to contact you?
That's 740-744-237.
740, 744, what was the last part?
1037.
1037. I'll give you a call, probably tomorrow, but I'll call you. We'll talk.
All right. Thank
Okay.
you, sir.
Okay, so Mr. Davis, you're going to get out of jail on your signature. 1,000. You'll get out on a signature bond with a promise to stay away from Ms. Brown and be at court on June 30th, 10 o'clock.
Will be, sir.
Okay, that's all.
State of Ohio versus Damian Fox at the Lawrence County Jail, case number CRB 23307A and B, and Eric L. Summers is on deck. Mr. Morford's case.
Mr. Warford.
He's in the office. Well, second this week, out of his clerk's office.
this is Damian Fox.
Your Honor, on Friday, we had a discussion about whether Mr. Fox had an adult parole authority holder
Yes.
and whether we could be releasing him to treatment because of that holder. I don't know if Mr. Morford came up with anything.
They were not in, Your Honor. I haven't had a chance to come off the shift, but as I go between cases, Your Honor, I'll call and see if they were in this morning. They're very hard to catch.
Okay, what we'll do then, Mr. Fox, Mr. Morford's trying to talk to your parole officer. He hasn't been able to do that yet, so I'm going to put your case back to be recalled later docket. He's going to try to get a hold of your parole officer today so we can discuss it. As of now, you can't get out because you have a holder from your parole officer, as I understand.
Yes, sir, I couldn't get out already because of the hold number, but is there any way that I can let it smooth out to this case? I feel like you should be honest and good, but I don't want to sit here and say, that I'm not counting for the parole. I need to be a human and the front of the county jail and parole, because you can't put it on parole. So I'm going to go ahead and make a statement, plea deal, whatever it is, something, go ahead and get parole bill. Because waiting on parole, all this is called dead time. Like, all this does not even count.
Well, let's let Mr. Morford try to find out something before we do that right now. The day's early, he can make some phone calls and see if he can get additional information.
And then could I call Mr. Fox, Your
Sure.
Honor, with the cases we called, so I can discuss those matters with him that he just addressed?
He'll try to get some more information and call you before we have you back in court. We'll have you back in court before the day's over. You're welcome.
Thank you, Judge.
State of Ohio versus Eric L. Summers, case number CRB 2372, TRC 211980 A and B, Orange County Jail.
All right, and this, actually, Mr. Smith, is still your case. It's been a while. 2372, 211980 was set for a pretrial on February the 10th of this year, and it's alleged Mr. Summers did not appear at that time. So it looks like there is, that matter still pending. It was the charge of a theft offense from Walmart, and he also has a prior OVI that he'd already pled out to. And looks like most of it actually was done. But he failed to appear for, it's alleged he failed to appear for a pretrial conference on February the 10th.
Judge, I'd have to defer to him because I don't have my file, why he did not show up that day.
Okay, so we'll let you call down, talk
Yes.
to him. You can have the court's files.
Thank you.
And then after you've done so, we'll recall.
And, Your Honor, just maybe to help Mr. Smith along here, he actually had a day in jail back in January, and so he's probably got more jail time now. So that might help to grease the skids or whatever.
Okay. Okay. That, for now, that finishes what we can do at the jail. We'll come back to them later.
State of Ohio versus Brianne Hensley, case number CRB 23350.
Brianne Hensley.
Yes.
Ms. Essentially, it's alleged that Fayette Township on June 11th, you tried to deprive Walmart of property without their consent. That's a first-degree misdemeanor theft offense, maximum penalty, 6 months in jail, $1,000 fine. Do you understand the charge, ma'am?
Yes,
Do you understand your rights?
yes,
How do you plead to the charge?
not guilty,
You wish to have a lawyer appointed.
please.
You have a job?
No, I've been taking care of my mother-in-law that has cancer. I had to leave my job.
All right, Mr. Thompson, I'll appoint you to represent Ms. Henson. You're in not guilty plea. She has posted a bond, so that's continued. And June 26th or after?
You can name it.
June 26th is okay?
Yeah,
That's a
that's
Monday.
fine.
June 26th, free call, 10 o'clock.
Thank you.
You're welcome. My guilty plea is entered.
State of Ohio versus Ryan Christian, case number CRA 23351, TRC 23696, A and B.
And sir, are you Ryan J. Christian?
Yes, sir.
Mr. Christian, you've just been handed copies of the charges. Most serious is CRA 23351. It's a possession of cocaine charge, alleges that on June 9th of this year, Perry Township, he knowingly were in possession of cocaine. That is a Schedule II substance. Maximum penalty for possession of which is a year in jail, $2,500 fine. You're also charged with some traffic offenses, 23696 A and B. The A case alleges that you were operating a vehicle under the influence of alcohol, drugs, or a combination of those things. That you took a breath test and tested 0.88, so it's over the per se level for alcohol, but not by much. It is alleged to be your first offense within 6 years. So the maximum penalty is 6 months in jail, $1,075 fine, 3-year license suspension. Minimum penalty is 3 days in treatment, $375 fine, 6-month license suspension. You're also charged with speeding, driving 73 in a 55 zone. Do you understand the charges against you?
Yes, sir.
Do you understand the rights you have as a defendant?
Yes.
How do you, well, you got a felony, so I shouldn't ask you for a plea, so you can't enter a plea at the first hearing with a felony. Do you have the money to hire a lawyer?
No, but I will. I get paid every 2 weeks. I
Do you want to be considered for a court-appointed lawyer, or you want to hire your own?
yeah, quarter point.
Do you have a job?
Well, I've got an income coming in. I got my foot smashed by a branch about a year ago, so I've been off work for about a year and a half.
But you get workers' comp? Or
yeah.
what? How much do you get in workers' comp?
I get $13.44 every 2 weeks.
Okay, so you have dependents, you're getting about $30,000 a year that way. You get, do you have any anyone dependent on you for
No.
support? You're a single person?
Yes.
Okay, well, you will have to hire your own attorney because you're making too much money for me to appoint a lawyer for you as a single person. How much time do you need to do that?
I get paid every other Monday, which I get paid, next time I get paid, which is Monday.
What's the state's position on bond? Is this one that you would be willing to allow Mr. Christian to go to treatment with an OR bond and keep it in this court initially?
Well, it appears on the face of it that yes, we would. We want to see him do that. So as long as he agrees to be assessed for treatment, then we would not oppose an OR bond.
Your Honor, I've actually already got treatment set up.
Where's that?
Recovery Point in Huntington, West Virginia.
So you're gonna go there and stay, or?
Yeah, my father had sent a acceptance letter earlier.
Oh, wait a minute, I've got it here.
He said-
Matter of fact, they didn't know who to give it to, but I've got it. Can you
Okay.
take one up to the judge?
Dated today saying you've been accepted.
Yes, sir. I've been trying to get in there. You know, I know I've definitely got a problem with it, but I've been trying to get in there. He just had been trying to get me in there for a while now.
Okay. So is this state agreeable with this?
Yes, Your Honor, and, you know, this is a felony possession charge, and we could, by rights, take the case on to the grand jury and pursue it as a felony charge, which could have serious consequences, but we're willing to give Mr. Christian the opportunity to go through treatment here and not have the case go there. We also have the OVI charge, which is going to have to be dealt with, and whether we agree to, you know, certain disposition on that is going to depend on whether whether he goes to treatment, and I don't know if that made sense or not, but we will be pursuing the OVI charge.
Okay, so I know you're not a lawyer, and there's a lot of legal stuff here, so let me try to break it down for you so you understand it. Felony, you have I think 3 charges. Yes, 2 misdemeanors and 1 felony. The possession of drugs charge is a felony. So what does that mean? Under our current system, a felony means you can go to prison. If you get convicted of a felony, that's where felons go, or can go. They don't always go there, but you can go to prison if you have a felony conviction. On a misdemeanor, you can't go to prison if you're convicted or not. You can't get into prison on just a misdemeanor. So 2 of these are misdemeanors, 1's a felony. So what the state is willing to do, if you will go to treatment, which you're saying you're going to do that, and are successful, they're not going to pursue the possession of cocaine as a felony. They're just going to keep it here in this court. This is not the felony court. So if you were to have a trial on a felony, you'd be down in Ironton at what's called the common police court. And before you even get there, you have to be invited. What does that mean? The grand jury, which is people sitting in secret, listen to evidence and decide whether there's probable cause to indict somebody on a charge. So they're not even going to do that. As long as you are doing your treatment and do well, they'll never take it to the grand jury. You won't get indicted. You won't go to the felony court. You won't be tried on a felony, and you won't have any risk of going to prison. But you got to do well in treatment. You got to do your end of it. So
I'm supposed to go today, I think.
it's a pretty good deal, but you got to do your part.
Yes, sir.
Okay? Do you understand all that?
Yes.
So what's going to happen is they're going to keep it here in this court, and you're going to come back periodically, and I'm going to get reports from recovery points to how you're doing. If you're doing well, we'll just keep it here, and eventually they'll dismiss. If you do really well, they'll dismiss the felony charge, but they're saying they're not going to dismiss the OVI. They're want to deal with that. So that has to be dealt with. That's a traffic driving under the influence, what we call it, operating a vehicle intoxicated now here in Ohio. So that's going to have to be dealt with. So,
Your Honor, if
Yes.
I didn't clarify before, if there was going to be a dispute about the OVI, a challenge to any aspect of the OVI, since it's tied directly to the possession charge, we would do all of that in common police court. So the OVI would need to be addressed here. And
so in other words, they're looking for a plea on the OVI at some point, or they can take it with the felony to the felony court. So they wouldn't drop the felony then, they would just take the OVI with the felony down to the felony court, but try both together. And again, you probably need a lawyer to discuss this with. And I would encourage you to do that, but you make too much money currently with your workers' comp for me to appoint a lawyer. But as of now, the main thing is you need to get into recovery point, and then I'm going to say, here, when you come back, and I need a report from them that you're there, and you're doing what you're supposed to do. And you probably need to get a lawyer before the next hearing. Okay, let's set it, well, the 26th would be within 15 days, so I'm going to set it in 2 weeks. June 26th will be your next hearing here.
We're also going to need a time limit, Your Honor.
And
So June 26th, Your Honor?
yes, 2 weeks from today. You have a right to make the state bring this case in a speedy fashion. But since you're the ones that, they're saying they'll eventually dismiss it if you go to treatment and do well, they're going to require you waive your speedy trial rights in order to keep it here in this court. Are you agreeable with that, sir?
What is it again, Your Honor?
Since the state's saying they'll dismiss the most serious charge if you go to treatment and do well, but it's going to take some time, they're asking you waive your speedy trial rights. In other words, if you want to have a speedy trial, then they're not going to dismiss it. They're going to go ahead and take it to trial right away. So you agree to waive those time constraints that your case has to be brought in a speedy fashion, give you a chance to do treatment and get it dismissed.
Yes.
Okay, you'll need to sign something for that. I'm going to let you sign a bond, a signature bond of $2,000.
Your Honor, he had said something about a 6-month program over there.
That's fine. Yeah, 6 months can work. We'll work with you that time period. Okay, you're going to sign a signature bond, then you need to be back here 2 weeks, June 26th. Do you have any questions? That'll be at 10 o'clock on June 26th.
June 26th? No.
Bring a report with you or have somebody, sometimes they'll come and bring somebody with you to give a report to the court.
Okay.
From recovery point.
Yeah, I'm going to actually go there as soon as I leave here, so.
Okay, good luck.
Thank you, sir.
State of Ohio versus Jacob A. Burns, case number CRB 23297. Jacob Burns.
Jacob Burns. Sir, are you Jacob Burns?
Yes, Your Honor.
Mr. Burns, it's alleged that at Union Township on May 5th of this year, you not only caused Randy Kipp, believe you would cause physical harm to his person or property. That's a menacing charge. It's a 4th-degree misdemeanor. Maximum penalty is 30 days in jail, $250 fine.
Yes,
Do you
sir.
understand the charge?
Yes, sir.
Do you understand the rights you have as a defendant?
Yes, sir.
How do you wish to plead to this charge?
It's supposed to be dismissed, Your Honor.
I don't know anything about that. I mean, that's, the prosecutor files the charges, so.
Yeah, the prosecutor, they know what's going on. Should.
I don't hear, do you want to dismiss it, or what's the state's position on this?
Well, the alleged victim has come to us and said he wanted to dismiss the charge, and that could very well be the way that this ends up. However, we want to make sure that there's a period of time where we can make sure that there aren't going to be further problems before we agree to do that.
It was just a misunderstanding anyhow.
What we would do is just ask for a pretrial, and then at that time, we can make that decision. probably is something that we will be able to, as long as the victim continues to say that they want to dismiss it, we'll probably end up doing that, but we can't do it today.
Okay, I'm going to enter a not guilty plea for you, Mr. Burns.
Yes, sir.
Do you want to be considered for a court-appointed attorney?
No.
Okay. I'll let you sign a signature bond of $1,000. Is there any kind of protection order requested here?
We will not be seeking protection.
Okay, no protection order.
It's just a misunderstanding.
I'll set the next hearing for June 26th. That's 2 weeks from today at 10 o'clock.
June 26th.
Yes, sir, 10 a.m.
All right, Your Honor, I appreciate it.
Well,
State of Ohio versus Aaron Cottrell, case number CRB 23352. Your Honor, I've been informed that this defendant was bonded out of our jail. He was then arrested and is currently housed in the Western Region.
okay. All right, Aaron Cottrell has not appeared. He has a bond up with Mr. Soward, so I'll issue a bench warrant and notify Mr. Sowers that he failed to appear. Yeah, I set a bond forfeiture July 3rd. I'll text Mr. Sowers to let him know what's happened. July 3rd is the bond forfeiture.
State of Ohio versus Michelle Mays, case number TRC 23458, A and B.
This is Mr. DeWater's case set for pretrial.
Judge, this is a first offense OVI. It's my understanding that Ms. Mays wants to change her plea to this, and it's also my understanding that the state is willing to recommend the minimums as far as sentencing goes.
Okay, is that correct, Ms. Mays?
Yes.
State
And I'm sorry, Your Honor, what was the plea?
guilty.
Thank you.
We don't have any objection to the treatment as the minimums, Your Honor, the minimums required by law.
Anything you wish to say, Ms. Mays?
No, sir.
I'll impose a $400 fine. Court costs, 6-month license suspension, which starts the day of the incident. 20 days in jail suspended. 5 days community service, 2 years of probation. Requirement to go to the 3-day driver intervention program. She want limited driving privileges?
Yes, Your Honor.
And she can have a permit for community service, work, court, anything else that she's permitted for?
No.
Review hearing will be September 22nd at 9 a.m. On the speed offense, I'll impose a $60 fine.
Thank you, Judge.
You're welcome.
I'll have her see Mr. Major before she leaves.
And she'll unfortunately have to go to Scioto County as the closest county. She can go to any approved program, but that's the closest one for the driver intervention program.
Yes, sir.
State of Ohio versus Kevin R. Wilson, case number CRB 23209.
Set for pretrial, Mr. Delaware.
Yes, sir. I'm hopeful that the state may be in a position where they can move to dismiss this case at this point.
Your Honor, this is an uncle and a nephew situation. They've had a misunderstanding of some sort. It's not out of hand, I guess, but I think that this is a situation in which we have some assurance that there aren't going to be further problems between these two. So we would move to dismiss this upon the payment of court costs.
That'd be fine.
Can we do it today?
Yes.
Okay. Be dismissed on payment of costs. See the clerk.
We'll do that right now. Thank you, Judge.
You're welcome.
State of Ohio versus Devon Light, case number TRC 23559, A and B.
And Mr. White, have you hired an attorney to represent?
I'm just
Mr. Delaware, Judge. Yeah, your notice of appearance is in the file. This wasn't marked on the outside.
Oh, thank you, Judge. That's it.
Approach, Your Honor.
Yes.
Judge, based on pretrial discussions with Mr. Heald in this case, and due to some issues surrounding the score related to the stop, I think the state's willing to treat this as a low, an unaggravated OVI for sentencing purposes. However, they would be requesting, it's my understanding, that Mr. Light obtain an alcohol assessment to make sure there's no underlying issue that needs dealt with. I've talked to Mr. Light about that. He wants to change his plea today to guilty and is agreeable to the recommendation that the state's making.
Is that correct, Mr. Light?
Yes, sir.
You have any statement you want to make?
Yes, sir.
How do you pay for medical services?
Insurance.
You have health insurance?
Yeah, insurance.
Through work?
My dad.
Where's that through?
Can I check real quick?
It's private health insurance,
Private,
yes.
Yeah. Well, I don't know if he was in the courtroom when I discussed this before, but there's a limited number of places you can go to get that done.
Yes, sir.
That take health insurance, OVP, Valley Health, ProAct. Those are the sort of, the ones that are more medically, they have other medically based services that you can actually usually go there and use health insurance to get something done, so.
I'll try to help him get arranged with one of those providers, Judge.
Okay, I'm going to impose a $600 fine based on your test score, or you pay the court costs, 6-month license suspension starting the date of the incident, 20 days in jail, all suspended, to 5 days community service. Do you want him to do both the dip school and the assessment?
Well, I've considered that. If he has the assessment and it indicates that he should do some treatment, then maybe that should be taken into account as far as whether he needs to do the 3-day school or not.
Right. Okay, I'm going to leave it in the entry. Here's what I'm going to do. I'm going to leave it in the entry because ordinarily you have to go to what's called a driver intervention program, which is a weekend program. It's mostly counseling. You have to stay. If you go for an assessment and they say you need some counseling and treatment, that could actually wind up being more extensive than what you get on a weekend program, and you do that, complete it, I probably would delete it because I think it would be redundant to have you go to the 3-day school and do additional counseling. So I'm going to have you come back, and I want you to go get this assessment pretty quick so I can look at it and see whether you need to have go to the driver intervention program, or whether I can omit that as a requirement. So yeah, I'll consider that later. I'll give you a couple of months to go get that done and come back, and I need a report from those agencies. And you have to be, you have to be honest with them about why you're there, what your test score was, and that sort of thing, because they're only going to have your history to go on as to why you're there.
Yes, sir.
So let's set that for August 14th. August 14th will be your, we come back and I'm going to look at what you've done as far as an assessment. You don't want that done before then. Okay, then on the failure to control a $20 fine, there was nobody's property damaged other than your own, right?
No, sir.
All right, see Mr. Major in the probation office, and then after that, you're free to go.
Thank you, sir.
Thank you, Judge.
You're welcome.
I'll talk to you just a minute.
State of Ohio versus Amber D. Ward, case number TRC 2316A and B.
Judge, this one
actually
had,
said on the docket for trial date. It's my understanding there's been some sort of agreement reached.
yes, it's my understanding that Ms. Ward wants to change her plea rather than rather than have a trial in this case. She contacted me, we had a little discussion last week on this, and she advised me this morning that she still would like to change her plea. So,
Is that correct, Ms. Ward?
yes.
Is that guilty plea?
Guilty
Yes.
plea? What's the state's recommendation?
Your Honor, this is a first offense, and so we don't have an opposition to the mandatory minimums.
All right. Mr. Daugherty, anything you or Ms. Ward wish to say before sentencing?
No, Your Honor, that's what we had discussed with Mr. Heald. I think this is probably an isolated incident for Ms. Ward. She's a professional and has a good job, and just
Chris, does she have
bad
proof of
decision.
insurance?
She had, did you have insurance at the time of the stop?
Yes, they paid for the guardrail.
Yeah, that's...
Her insurance already covered the restitution to the guard.
There was a guardrail involved.
But it has been shown to the court, so under...
I have emails and stuff.
You have something with you that...
Yes, but the court will need to see your insurance card. So can you show that
okay.
to them? You have it on your phone or something?
Well, it was with my ex-husband. We were going through a divorce, but I can
You can
pull
get
it
it
up,
and show it
yeah.
to the court.
Here, this is not a system that I would set up this way, but this is the way it works. And you're an Ohio resident, so when you go renew your license, you sign something at the bottom that says, yes, I have proof of financial responsibility. That's all you got to do. You don't have to actually show it. But then when you get stopped and get a citation, you're supposed to show the card to the officer. If you don't, and you check no on your box, then once I process it and send it on to the DMV, they're going to suspend you for not having proof of insurance. So it'd be an additional suspension. So it's important that we have the card here before I send it on. Or, I mean, you can try to deal with the DMV, but that's a nightmare.
Well, so I have to get insurance in me because I'm not no longer
Yes,
there.
but what the judge is telling you is if you can show the clerk your insurance card, it's not an issue.
Oh, yeah. Like my old one during
Yes.
the wreck?
It's got to be at January 1st, I'm sorry,
Okay.
January
Yeah, I have it on
1st,
email at
2023.
least.
She's got it on her email here.
Yeah,
She can show it to the
call
clerk
my
today.
insurance sent me it via email too, so.
You can show it to Mr. Major, or go meet with him about your probation, but that's really important. I'm assuming she wants driving privileges.
Yes.
So I can't give you driving privileges, and I'll need a current one for driving.
She's got that one too.
Okay, all right.
Different card, but she has both of them.
All right, good. Okay, I'll impose a $400 fine plus court costs. 6-month license suspension, which is almost up. 20 days in jail suspended. 5 days community service. 2 years level 4 probation. Driver intervention program is required. Driving privileges with proof of insurance. On the failure to control, a $20 fine. So you need to meet with Mr. Major in probation today. That's how you get your permit from the drive. And show him the insurance cards.
Thank you, Judge.
Thank you, Your Honor.
And September 22nd, sir.
Oh, I'm sorry. Hey, Amber. September, what'd you say, Judge?
22nd.
Try to get most of that stuff done by September 22nd. If you don't have everything done by then, you'll have to come back over and talk to the judge. When you have everything done by then, I'll talk to you in just a second. Judge, Mr. Major asked me to ask you about a guy named Travis Jeffers that pled guilty to an OBI earlier. You told him that he should go seek treatment rather than go to the 72-hour program. Not this last guy, he was the one before that. But Mr. Major said the entry doesn't say that. Is that one you want to watch too, and then you can change the entry at a review hearing if he's...
I'll take a look at it. I don't remember the...
Okay.
Sir, that was think the reason I did that, because he was ordered to actually get treatment, not just an assessment. He was ordered to get treatment.
Right.
If he does that successfully, then I won't require him to go to the.
Okay. And Mr. Major said, as far as him monitoring these people, he won't know that, you said that, because it's not in the entry, so.
I'll add it.
Okay.
But I'm going to shoot a no dip and then we can get on that.
Okay.
2 lines of the extra.
Thanks, Judge.
Yeah, if it's not on the entry, I don't know it, Your Honor, but if you're
Bring it
going
back,
to...
I'll add it.
Okay. Yes, sir, Your Honor.
State of Ohio versus Jessica Albright, case number CRB 23-328.
This is Attorney Roger Smith's case set for pretrial.
It's my understanding, Judge, that the alleged victim no longer wishes to pursue the charge. Mr. Hill has indicated he would be agreeable to a 90-day continuance with the requirement that my client seek an anger management assessment. Of course, it'd be ideal if they both would, but I know the court has no jurisdiction over the alleged victim. But the only issue that she has is she has private insurance. That sometimes complicates who can see you. You have private health insurance. But she's willing to do that, given whatever assessments.
You don't want a protection order. Right. Okay, so we've spoken with Mr. Huffman, who's the alleged victim here, and I have suggested to him, and I think he was very receptive to the idea, there needs to be maybe some intervention as far as family-type counseling, whatever form it takes, and he's willing to take part in that too. Previously, we had indicated to the court at the last hearing that we felt that there was some mental health issues that maybe were contributing to the problems. So if they both are involved and they have you have at least one child together. Three. They have 3 children together. So they got a lot of stresses that any family would encounter, and it can be beneficial to them. So he's willing to go if she is, and we'd be okay with a 90-day continuance and let them go through that process.
Okay. All right, we'll go out 90 days, and in the intervening time, they're going to get some family counseling,
Yes.
looking in mid-September.
The only day that is bad for me is September 8th. Other than that,
How about the 15th?
yes, I can do that.
September 15th, time waiver.
Yes.
Yes. And we're going to dismiss the protection order on...
Protection order is withdrawn.
And I don't know whether there needs to be some discussion about where the counseling might take place and how that's going to be paid for.
Does she have an idea for...
You have an idea where you want to go?
For counseling, anywhere that there is available. I'm not really sure.
Yeah, I know it's limited because of the private health insurance, but I don't know if OVP does that, or you live here in Ohio. Where do you live?
Ohio.
I mean,
South Point.
she's in South Point.
But
Probably
she can go, it doesn't have to, it's my understanding, is she doesn't have to be a West Virginia resident to go to Valley Health.
Okay.
ProAct.
There's so many.
She can go to any of those, or OVP.
She's going to inquire, Judge, and find one of those agencies to do it, right?
If you have any problems
Yes,
with
sir.
that, if you have any problems.
So don't wait till September 14th to start
Yes.
calling immediately.
I will
Okay.
today.
Perfect.
The gentleman sits here.
See you. Thank you, Judge.
You did say something in the computer about no difficult.
Yes, if you don't mind. Yes, I think you can find out. Good, Roger.
State of Ohio versus Christopher L. White, case numbers TRD 23-440 A, B, and C, TRC 18356.
Mr. Smith's case, set for pre-trial.
Your Honor, this is charged as a driving under an OVI suspension, but the suspension would have been over some time ago, so it's more of a failure to reinstate. He's out there.
23-440.
Judge, if the state is willing to amend that to a fair to reinstate, my client would enter a guilty plea. He says he's got some old case. He did some community service on last week. He's doing some more this Wednesday. Is that right, Joe?
I'll have to check.
Yes. When did you do it?
I did it last week. Was it last week? No.
You did one day last week?
Yeah, last week I did Monday because he took me down on probation.
That is correct.
And he's set up for this Wednesday, right?
Yes, I'm
He
coming this
still has
Wednesday.
some to do on 18-357, which was an OVI prior conviction. Okay, so, what do you want to amend this to then?
Well, I guess it's a failure to reinstate, it's no longer a mandatory 3 days in jail, we don't believe. So I don't know what code section to amend it to.
45-10-12. That's the no operators.
And that's fine too.
No objection, Judge, to that.
Okay. So how's the plea to that charge?
Guilty, Your Honor.
Is there still a speed and a safety belt? Speed was 86 and a 55.
Guilty, Judge.
Okay, on the no operator's license, I'll impose $150 fine, court costs,
How much are court costs?
$110.
110, okay.
On the speed offense, I'll impose a $150 fine because you're going 86 miles an hour. That's not reasonable. That's the max. $150 fine on the speed. Safety belt's a mandatory $30 fine. And I'll set that and the prior case that the 18-357 for reviews on July 14th. So everything's July 14th is your next review date.
You said July 14th, Your Honor?
Yes, sir.
Okay.
That'll be on this entry you'll need to get from Mr. Major.
Yeah. We need to go to the probation office and talk with Mr. Major.
State of Ohio versus Joseph M. Hermes, case number CRB 22658, CRB 22655.
Yes. Mr. Smith's case.
Appears to be a good report, Your Honor.
order the ankle monitor come off.
Thank you, Your Honor.
And how's the state want to handle the underlying charges?
Very encouraging that he's doing so well in treatment. I know there's a lot of people surrounding him, family and whatnot, who are very concerned, have been, about him, and hopefully he understands that now and accepts that and wants to do right by everybody, including himself. So we want him to continue in that. In the recent past, at least some of our victims have voiced their opinion that there should be a conviction of some sort. But we want to allow him some more time to go through treatment to determine exactly what our position should be. Certainly, the better he does, the better everybody else is going to feel about what's happened in the past.
And it hasn't been, even though the charges originated last fall, there was some gap in time before he got here.
There was, Judge.
So let's come back in another
Yes, sir.
approximately month or maybe a little longer. And I will order the ankle monitor removed.
Thank you, Your Honor.
Get that done with Mr. Major today. Set the next hearing, July 24th.
That is the first day of a murder trial. That's definitely going to go.
31st,
Of,
July 31st.
oh, yes, July, yes, I can do that.
July 31st.
Proceed then. Thank you. Thank you, Your Honor.
You're welcome.
State of Ohio versus Kelly Doss, case number CRB 22694 and CRA 22670, CRB 22671, A, B, and C. Kelly Doss. Not checking.
Probably at the Lawrence County Jail. He
I was going to say he was in jail.
He has a CCS violation trial this Wednesday. I was going to ask it be reset to this Friday or Tuesday if we're off June 19th for the holiday. So we can find out Wednesday what happens with, we'll get some resolution, whether it's a plea or a trial on Wednesday.
Said continued to this Friday, the 16th.
I'll be here, Judge, yes.
June 16th.
Yeah, we said it today because it was supposed to be last Wednesday, but it got bumped a week is what happened, so we can do this Friday.
State of Ohio versus Lee Kip, case number CRB 23211, CRB 21914. Case for Mr. Smith.
It's an assessment for the,
That's his assessment.
He's supposed to pay restitution.
yeah, I make a monthly payment, and that's for a assessment of my council. I'll make it a $45 payment today. Yes, sir.
And Judge, I was advised by Mr. Stratton that part of the situation is he owes restitution. In this case, he is going to make a $45 payment today.
Yes, sir.
Didn't make payments.
Yes, sir.
He's going to make another payment today in the amount of $45 towards that restitution.
Well, I think we need to have a screen based on what he screened last time he was here. I think I'd like to see another screen, see where we are.
Call back up.
So have him back out after he does it.
State of Ohio versus Laron C. Beach, case number CRB 23162.
Mr. Tyler Smith's case.
Approach, Your Honor.
Yes.
Your Honor, I've advised Mr. Beach of the recommendation by the state. I think what we can do is just set it for a short continuance to another pretrial. I believe that we'll have it resolved at that time, maybe 2 weeks out. I think I'm already here the 26th.
All right. Matter will be continued to June 26th for another pretrial, 10 o'clock.
All right, thank you, Your Honor.
You're welcome.
State of Ohio versus Heidi Gwynley, case number CRA 28316 A and B.
And this is Mr. Roger Smith's case. Roger Smith and Court.
Can I approach y'all?
Yes.
Judge, we had spoken previously, did you talk to Megan? Is she good, Megan?
Yes.
We'd spoken previously about, Mr. Hill and I, about possible QRT with an amendment of the F3, so she'll be able to do the QRT. It's my understanding she has spoken with Megan and she qualifies for your program.
She does.
And I think, I'm not sure if we can talk about what to amend it to, but as long as it's not an F3, I think that would be beneficial to her and the state if she got some treatment.
Your Honor, the tampering with evidence charge is one of the, what I think we consider the more minimal kinds, where the person maybe throws a baggie under the car or in a car seat or something, while, as opposed to some more serious form of tampering. So in order for QRT to be able to take over the case, they can't take over a case that has been a third-degree felony. So we would move to amend that tampering. I don't know whether is there an F5 version of the tampering? I can't just nolly it outright because it's been an F3, so it has to be something less. Attempt to be an F4. Is it F4? I guess an F4.
Can you do a QRT?
So we would amend it to an F4, and then upon the court's approval of the case being handed over to QRT, we would just be nolling both charges to QRT.
Okay, so we'll call it an F4 tampering with evidence, and it'll be nolling to QRT. And you got to comply with their supervision, and if that doesn't happen, they can bring it back to court here or send it to the grand jury for indictment.
Yes, sir.
Okay. All right, case here is nolling.
Thank you, Judge.
You're up.
Federal Highway Taylor Bryan, case number CRB 23-112, CRB 20-112. Taylor Bryan.
Yeah.
Yeah, but he's already incarcerated and stuff.
Okay. It's just
Yeah.
Okay. Yeah.
Your Honor, I believe that we're going to have a change of plea. This is an M1 theft from Walmart, so basically the recommendation is just the standard treatment for first offense.
23-112, 20-112. She's in treatment now.
Yeah.
Where are you?
Mountain State Recovery.
Mountain State Recovery on Mountain State Recovery, I believe is where she's.
Yeah.
How long have you been there?
supposedly like 4 months.
4 months.
It's outpatient now.
Well, I'd like to see a urine screen because it looks like initially, and I mean, that's my standard policy on these kind of cases, but even more so here because I think initially Bond mentions some sort of possession charge was going to be filed.
But it wasn't.
I know it wasn't, but it indicates to me there's a drug issue, so I want her to go do a urine screen
That's fine.
before I send it. So go do a urine screen, bring it back.
Yeah, that won't be like, because I have a prescription.
Your prescription's on.
Okay. Then, yeah. So let's do it again.
State of Ohio versus Casey J. Jackson, case number CRB 22510, CRB 222595, A, B, and C, and CRB 22165, A and B.
Mr. Jackson is here today. He came in Friday, and he was out here than Mr. Smith, so he had missed a hearing.
I believe the second.
Second, yeah. He's supposed to be at half.
I just forgot. Do you have a report from Matt? She said it was here.
She said it's here?
She said they sent it, June 2nd.
I don't know if there's a report from June 2nd in the, from, when you're supposed
April
to.
28th appears, let me look to make sure I'm not missing it. Yeah, I don't have one more recent.
His counselor, I guess, his counselor advised him that it was sent June 2nd, because he's supposed to be here in court, so I don't, if you don't have one, I don't have one.
Yes.
I'm looking at his phone now, the counselor says it was faxed in.
Oh, faxed, okay. We can have somebody check it. It was faxed June 2nd, though?
That's my understanding, yes, Your Honor.
This is Friday.
Okay. This is a text from last Friday, yes, and it was faxed in.
Well, let's recall it. Would you go?
There's nothing on the document. The last time he was here, Your Honor, fax did come in that afternoon, and I stuck it in the folder.
I'll let you see if this was placed.
That's what I get today.
The last one I have in the file stated April 28th.
John, may we approach real quick?
Yes. This case will be recalled later in the docket.
State of Ohio versus Justin Stapleton, case number CRA 23288, TRD 221021, A and B.
It's Mr. Thompson's case set for approval. The preliminary hearing.
Pending now. Even apparently he's got some problems. Come on. As long as it's not- Yeah, sure. Not if his license is suspended for something other than a court order here.
This would get rid of what's here.
Yes. Well, if he's already waived his right to claim here, or to extradition, then that's, well, then it's just a, is he presenting something to court over there? Has he got something to show that? I mean, that could be dismissed if the court.
This is where from Ashland. Release from okay. Man, I wish I could. This is where Ashland, this is where he paid. This is
Okay, that's good. Well, that should say that here.
Okay. Your Honor, we've got two things going here. The Rule 4, which I believe he's taken care of. He's got proof here that he
posted bond, paid the bond, and got a court date.
he's got a court date, and the bond has been released. Is that right?
Yeah.
Okay.
Well, can we have someone from the prosecutor's office check to see if that warrant's been withdrawn? If it has, then we can dismiss that.
This is the paper here on it. It's emailed
We can
from
do-
Ashland Courts.
Here's the
You
file.
can scroll up.
Well, that looks,
Might have to scroll up and see it all.
Your Honor, he's shown us a release of warrant from the Ashland, Ohio Municipal Court. Court finds that the warrant block previously declared should be terminated, hereby orders the Registrar of Motor Vehicles to reissue the license to its original date of expiration or permit. That's June 8th, 2023, signed by the clerk, deputy clerk there at the Ashland Municipal Court. I mean, this looks authentic to me.
Okay.
So,
So that's 23-288. We'll dismiss it.
Okay.
So that's 22-1021 and 21-695 in here.
The DUS, the no seatbelt, correct?
They're traffic, but yeah.
Right. Okay. Well, we're a little unclear on this, but he would like to go ahead and plead to those if whatever the standard sort of fines or would be in place, and if this would clean him up here to go ahead and apply for at least a restricted or his license. Correct.
Yes, sir. This was the proof of insurance showing, so we need to provide proof of insurance on that date of that.
Yeah, proof of insurance.
We had it during the time, I don't know. We had it at the time.
It was March of 2021, March 26, 2021.
Where do you live? We live in Chesapeake. Okay, can you get that proof and bring it back?
Probably not at this time.
Why not?
Because I don't have the paperwork all together.
You want to get this moved 1 week, then and you can get your insurance, so you can raise the court. We'll do the same thing.
Yeah, I mean, I would like to get it over with.
Well, but this is a real hiccup here.
The insurance, they had insurance, but we should have showed it at the point when I come in.
So it's not showing that he showed the insurance?
Not on the earlier case, the March 26, 2021 case. Did that show he had proof of insurance on the April of 2022 case?
No.
So he needs to go back and, did you buy your insurance from a local agent or how did
It
you?
wasn't even my vehicle.
Okay.
And so the person that the vehicle belonged to did have insurance, but we would have to go through a process to try to find it and such. If that's a possibility, I would be glad.
Well, there's two ways you can satisfy this. If you had insurance on yourself back in March of 2021, you can go get a card that shows you had coverage for yourself, because it goes with you to any car you're driving with permission of the owner. Or if the car you were driving had insurance, you can go back and try to get the card, a copy of it to show. Because otherwise, if you plead on this, you're going to get another suspension from the B, not from me, but from the B&B, because they're going to see that you were driving without proof of insurance.
Let's continue it 1 week.
Yeah.
Your Honor, could
So
we?
probably just continue it?
Yeah, 1 week, and is that going to be enough time?
Yeah, that's fine.
1 week is enough?
Yeah.
Sure.
Well-
Is it possible if we bring it in and show it to the clerk that we could get
It
it?
has to be today.
You can do it today, because once we accept it, then we've got to send it in.
I might be able to get it today, I just have to check with someone.
We're going to have to continue for a week.
Yeah, that's fine.
Okay.
Well, the week is actually going to be Tuesday,
Well,
because next Monday is a holiday.
I can do
Is it
Tuesday.
10 or 2 weeks?
1 week. I'll do Tuesday.
On 20.
Do you think you can get it in
Yeah.
1 week?
Yeah, we
Okay.
should have it today, maybe.
Okay.
Okay, 6:20,
6:20.
10 o'clock, most cases.
And that was which vehicle was it on? What day was it?
Case number 22-811, CRB 22-813.
Mr. Thompson's case, under hearing and pre-trial.
Your Honor, we've had a couple hiccups trying to get this anger management done. My client's lost his vehicle, he's lost his house. It's been a sort of a mess, but we now have a plan through Taylor at Spectrum to get this done. That's Bethesda, sorry, there is no Spectrum. To get this done in about a month.
Okay. Stay agreeable with that?
Well, that's what Bethesda recommends, another month to make sure he's being compliant. Is that basically the?
He'll get a certificate. All right, you guys get a certificate.
Yeah, we don't have an opposition to that.
You prefer Mondays?
I can do Fridays now if you want.
14th or 14th is a Friday, 17th is a Monday.
Let's do 17th if you don't mind.
July 17th.
Thank you, Your Honor.
You're welcome.
Thank you.
You're welcome.
State of Ohio versus Brian Kitts, case number TRC 222478, A, B, and C.
Stars case, that's what we're trying.
Your Honor, I have requested and received discovery on this matter. Need to go over the video and meet with my client regarding the same, so I'm going to ask to continue the matter to a date convenient to the court. We would waive time constraints to accomplish that.
I don't know if you're available, 26th or the 30th are not bad.
The 30th, Your Honor.
30th, June 30th. 10 o'clock for pretrial.
Thank you.
State of Ohio versus Terry Aldridge, case number TRC 23544, A and B, CRB 23304. Terry Aldridge, did not check it out.
The Aldridge is Mr. Stiers' case, pretrial.
Your Honor, I've checked out there for him several times and not gotten a response.
Got a week to appear or more wish.
Thank you.
State of Ohio versus Hannah Suttles, case number TRC 23430.
It's Mr. Stiers' case, pretrial.
Your Honor, a couple different things to deal with today. Ms. Suttles is at Mahajan. The state was asking about treatment for Ms. Suttles due to some of the circumstances surrounding the charge. She is at Mahajan. She has executed a release to give information to the court, but I don't think any requests have been made. So my intention was today was to ask for a continuance to go through discovery with Ms. Suttles, and at the same time, once we had the new date, we could ask Mahajan to provide a report next time we're in court. And then further, Ms. Suttles would like to seek limited driving privileges for employment and court and treatment purposes.
Well, as far as the driving privileges, we won't take a position now. The stop was on April the 21st, so I don't know if there's what the time range is on that. This is a second offense. And I will also say that it's a second offense this year in 2023. So,
yeah, I was thinking at first, it's not. Probably second. 45 days, ignition interlock required if alcohol related.
We're outside the 45 days, I believe. If it was April 8th, you said?
In the reported odor of alcohol, so she would have to have ignition
You'll
interlock.
have to get an interlock, which is about $1,000, I think. How much does that cost? About $1,000, is it not? Is that what we've been told?
Roughly, I believe.
Yeah. So, but if she were to get that and bring it in and show it to Mr. Major,
She could go talk with him and he can give her the details about it.
Okay.
There's a company in Portsmouth, I believe, is where they're located, where you have to get that arranged through them to get it installed on the vehicle.
Okay. And then regarding another date, that date of the 30th works for me as well on this one, or we go a different date.
June 30th.
Thank you, Your Honor.
You're welcome.
June 30th, 10 o'clock, and ask.
State of Ohio versus Kimberly Thompson, case number CRB 23177.
Stiers' case, pre-trial.
I think we're going to need to set this matter for trial, Your Honor. I'd like to go a little further than the 30th because there are going to be some witnesses I'm going to need to get subpoenaed.
Okay.
And I'm going to be gone here briefly. So I don't know what days after the 30th are good days for the court.
Pull it up.
Are Mondays or Fridays one better than the other for you?
Mondays.
Mondays are better for Ms. Thompson, so if we could do a Monday, that would be preferable for the defense.
The 3rd is fine.
I'm available the 3rd, Your Honor.
At noon.
Yeah. Thank you.
Set it for trial July 3rd at noon.
Be here at 10 if you don't care.
At what time?
It's set for noon, but try to be here at 10 if you could, so that I can talk to you beforehand.
All right.
Thank you, Your Honor.
State of Ohio versus Cameron Weaver, case number CRB 23284. Cameron Weaver.
Mr. Spires, case pretrial, 23-284.
May we approach on this, Your Honor?
Yes. This case will be recalled later in the docket.
State of Ohio versus Roberta M. Abbey, case number CRB 23270 A and B. Roberta Abbey. Roberta Abbey.
I didn't hear him call my name. No, I said not there, I didn't hear it.
So, from what I recall, yes, and they need her to sign power, the medical power of attorney, and she wasn't going to be agreeable to it, no, she did not, because she is guaranteed, she's guaranteed 10 years.
She's with Sierra's dad. Yes. She's with her girlfriend's dad.
Yes.
Her girlfriend's.
Did she ever sign power of attorney for him? Did she ever sign power of attorney? So, her daughter's was 18 and they had talked about her signing a power of attorney so he can get her medical help if she needs like medical power of attorney. See, the person her child's with is her friend's dad. It's the little girl's friend's dad. And they had talked about her, the mom, signing over a medical power of attorney. So that way, because that girl's going to be turning 18, if she has to go to the doctor or anything, do you know if she's done that? If she is pregnant, she's going to say.
Are they still going to keep the protection order? Are they still keeping the protection order?
Are you still maintaining protection order?
The CPS told me not to do one unless until I find out what happens in court. Yeah.
So she doesn't want to do that.
She's been advised by CPS not to do that, Jess.
We need to call our Children's Services. So, Your Honor, Children's Services became involved in this, and we'd had some contact with Children's Services, and then we had a computer crash, I guess, where the notes were kept. I think we need to, I think Stacy Holly is the one on this case. She was, her name's on here, but so we can attempt to get a hold of Children's Services and see from their perspective what the status of this is, if the case can be recalled.
This is the second time.
I'll just text them.
She is not.
It's one of the new ones.
Trying to get Children's Services, they should never recall it. They haven't made decisions yet.
It's in my computer, but I can't remember if I can get those things back. It's one of the newer guys.
CPS said that they've sent over a full report. So I don't know what they're waiting on.
And that's what you're doing now, is texting the Children's Services?
Yes, Your Honor.
Okay, so you want to just recall this?
If we could,
I just spoke to him like
Be
15
recalled.
minutes ago.
State of Ohio versus Stephen Thompson, case number CRA 19235, CRA 22617, TRC 222476, A, B, and C.
Your Honor, no, you can be served Saturday, if they have any questions.
Thank you. Good report. How's the state want to proceed?
It sounds like Mr. Thompson is making a sincere effort, which is encouraging. He's already been sentenced on the OVI, and that just leaves the felony possession charge pending. I don't know whether the counselors would agree that he's reached a state of, in his counseling in which he would not require anymore or not, but he probably has a ways to go.
He does have a ways to go.
He's doing good, though. which
Yes,
is-
sir.
Hopefully that makes him happy, too.
Yes.
So we would suggest that we need to come back at a later date, make sure he's making more recovery.
Are you working now, Mr. Thompson?
I'm working part-time.
About 2 months then, this time, Mr. Moore.
That sounds good, Judge.
August 14th.
I'm here then.
All right, August 14th will be Mr. Thompson's next hearing.
Thank you, Your
At
Honor.
some point, you'll have to start working on the other case too, to get some of that taken care of.
Thank you, Judge.
Thank you, Your Honor.
State of Ohio versus Lee Kit, recall, case number CRB 23211, CRB 21914.
Didn't mean to be a crash. Something hopeful.
Yes, sir.
Concerned about the oxycodone.
Yeah, I have not seen the report, but I talked to Mr. Stratton's client. He advised me what he tested positive for. I know in speaking with him that it didn't start out as a drug case. He had voluntarily sought treatment ahead of time, I think in Riverside at first, and then wound up, he's in a new beginning currently. He was going once a week, now he's going twice a week.
Yes, sir.
He is addressing the problem, Judge, but that is a concerning result, I would agree.
Now, I know you're going to a new, is that where you go, are you year at Riverside for your?
No, sir.
Not at Riverside at all?
No, I do everything at New Beginning.
I think you started out at Riverside and you transitioned over for some reason.
I went to a briefing, I guess. Assessment, and then they informed me that I should go to New Beginnings to continue that they weren't able to prescribe the Suboxone apparently.
Well, I'd like to have, and I guess I can, send this to this lady's email address. Boggs.
Yes, sir.
Okay. Well, does he think that this is a prescription, or why would he be tested positive for oxycodone?
That's what I'm going to get some treatment for, sir.
I'm sorry?
I'm sorry, I
Why
misunderstood.
would you test positive for that if you're not?
Is that a prescription? Is that something you're using?
No,
That's why
sir.
you're seeking treatment?
That's why I'm seeking treatment, sir.
Apparently it's not a prescription, Judge. That's why he's in treatment for the oxycodone situation.
Okay, well. Okay, well, we need to figure out what we're gonna do. One of these is criminal damaging, I think, from 21.
I think that's the one he's going to pay 45 restitution on today. He's been, I don't know how much he's paid, it's Mr. Stratzky's, but
Been making monthly payments.
he's been making monthly payments, same amount.
No, it fluctuates.
Okay.
Whatever.
He apparently has been making payments in various amounts once a month.
Have steady income now, so it'd be.
The other's violation of protection is recent. That's
Yeah,
recent.
she dropped that. She spoke with him, she was here last month and dropped that.
He's telling me that she thinks that might have been resolved last month, that she didn't want to proceed, but again, I apologize for not being more familiar. I'm helping Sean.
It's still pending.
Oh, jeez.
It's still,
All right, let's come back on July 17th.
he just texted back, any date would be fine, so July 17th will work, Judge.
Won't have any more.
No, he had to go with Sean, I'm pretty sure you guys need to talk.
Yes, sir.
We got something going on.
I know.
All right.
Apologize for
Thank you,
waiting.
Judge.
Brandon L. Anderson.
Thank you very much.
Case number CRB 23294.
Okay, negative screen. Very good. So I'll go ahead and sentence you, Mr. Anderson. I'll impose a $100 fine.
Did you plead guilty, Your Honor?
He pled guilty.
Thank you.
$100 fine. Court costs. 10 days in jail, suspended on the conditions you do 5 days of community service here at the court and stay out of Walmart. Serve 2 years of well before probation with a review hearing on September 22nd of this year. If you get everything done by then, you don't have to come back. That's a hearing to determine if you did do what you were ordered. You're going to meet with your probation officer, Mr. Major. When you leave the courtroom, make a 90-degree left turn, go over to that counter. He'll be right in front of you. And check in with him and sign up for probation.
All right,
Do
thank
you
you.
have any questions, sir?
No, sir.
Okay, that's all.
State of Ohio recalls Taylor Bryan, case number CRB 23112, CRB 20112.
Okay, it's a good screen. Okay, a good screen. So what's being recommended on 23-112?
Your Honor, I believe that's the Walmart theft case. I just want to recommend the standard.
Okay. Now I'm fine with that. Now that our screen is back. Okay, I'll impose a $100 fine on court costs, 10 days in jail, suspended. Order to stay out of Walmart. 5 days community service, 2 years of probation, and set for a review hearing, because she's got an older case, so these will be set together. July the 24th will be a review hearing on both cases, 20-112 and 23-112.
I'm sorry.
July 24th.
Thank you.
She'll need to go meet with Mr. Major, which is free to go after that.
Thank you.
Thank you, Your Honor.
State of Ohio recalls Casey Jackson, case number CRD 222595, A, B, and C, CRB 22165, A and B, and CRB 22510.
Your Honor, as we talked prior, it looks like we're going to try to change providers, and he's met with Cardinal, and I believe that he's good to start treatment there, and hopefully we'll have reports and everything we need to so we can proceed, because this is dragged out for a while now, and we'd like to get him squared away.
When do you want to come back?
Maybe 30 days, I don't know if that's too far out.
That's fine. July 17th?
That's fine.
July 17th will be Mr. Jackson's next hearing dates on all his cases.
Thank you, Your Honor.
You're welcome.
State of Ohio recalls Tiffany Phillips, case number CRB 22680.
Your Honor, if I may, Mr. Major told me that the phone call he had on her that she was going to be in late, but she won't be here Friday.
Yeah, that's real late.
Yeah. I misunderstood.
All right, she's got 7 days to appear before Marcus.
Your Honor, I do have a progress report to put in the file.
Okay. Thank you.
You're welcome.
State of Ohio recalls Andrew Curry, case number CRB 23291, CRB 2361.
Your Honor, when last I checked, he hadn't checked in.
All right, so we've got 7 days before Marcus.
Thank you.
State of Ohio versus Shandon Pringle, case number CRA 22563, CRB 22564, CRB 2189, CRB 22295.
Mr. Smith represents Ms. Pringle.
Your Honor, can I approach?
Yes. It's a good report. Congratulations.
Thank you.
Well, we're pleased that she's got a good report. We want to keep going.
Yes, sir.
And at some point, hopefully, the program will say that she's reached a level of completion where they feel safe in cutting her loose, but I think at this point, maybe she's still involved in the program.
Is that agreed?
Yes, Your Honor. Come back. I believe we just set one for July 17th. Set
All right,
that same date.
July 17th is the next one. On all cases. Okay, good job. Keep it up.
State of Ohio versus Mary Hampton, case number CRA 23320, CRB 23321.
Byers case. Now, approach Gomez.
Because I'm wanting to get this suffocate shot, and she wants this done first. She's worried about that mass. But I just put in writing. I called her today and told her we could talk tomorrow.
So we have a report from RRG. It's a good report.
Your Honor, I guess that the QRT program is interested in having her as part of their program, and I guess they feel that this is an appropriate time for that. Okay, she's already being overseen by QRT.
Okay.
And they're asking at this point that we go ahead and nolly these charges. Now, it seems like there was also maybe a theft charge. How this, yeah, so that needs to be resolved. I don't know how they want to proceed with that.
Yes.
So you all will take somebody that's out of state too?
Out of state, yes.
What do you do with the theft charge?
Walmart.
We can take them.
Well, I mean, I think that that's one that should be dealt with. We're happy for the felony possession case to go with QRT, but we need to resolve the Walmart theft.
Well, our understanding when we spoke to Brad about the QRT program was that the entire case would be taken to the QRT. I don't know if, is he still here, Mr. Lehman?
Yeah.
Well, we don't want to just dismiss it. Well, I mean, well, there isn't any restitution. So the question is whether we would agree to nolly the theft charge as well, but, you know, there's a third party involved in that situation, the Walmart. So we don't have a problem with the felony theft charge being nollied to QRT, but we need to resolve the theft charge in some way, either with a plea or a trial.
Then, Your Honor, let's set the theft charge for another pretrial. I hadn't filed discovery, I thought it was going on with the other case. And I'd like, before I have her plead to something, I'd like to see if there's actually evidence.
Okay. So, but are you agreeable with the felony going to the QRT?
Yes, we're agreeable with that.
Okay. So it'll be only on the misdemeanor theft, the pretrial. When do you want to come back?
If the 30th is not getting too heavy, we can go to the 30th. If that's getting too heavy, we can go to The 3rd.
Let's do the 3rd. July 3rd for pretrial on CRB 23-321.
10 o'clock, Your Honor.
Yes.
State of Ohio versus Brittany Rowe, case number CRA 22659. Brittany Rowe.
Mr. Spires, stay set for preliminary hearing.
Your Honor, I think this kind of balls the state's court on this one at this point.
This is a case from 2022, and it appears that the primary actor in this case has been charged with this theft as well. And as far as the state's ability to prove that she was involved in a theft, is not much evidence there to support that. So I believe what we'll do is nolly this charge, and the intention is not to take it to the grand jury.
All right, case will be nollied.
That means dismissed. Thank you.
State of Ohio versus Gretchen Smith, case number TRC 221661A and B, CRA 22502A and B, CRA 22393A.
Mr. Spires, please.
May I approach?
Yes.
Been provided this court update from Sunrise. Previously, we also have a representative of Sunrise here.
All right, so you say 24 hours, that will complete her program? Is that correct?
That's my understanding, Your Honor.
And when do you expect that would be?
When do you think you're going to finish up?
I'm in transitional living right now. I'm working full-time. I'm just in sober living. I've already completed the inpatient and all of that.
Right, but there's some other programming. They said you had 12 hours out of 24, or 24, was it? I didn't keep a copy of that, Your Honor, but it said.
It says, I'm reading directly from it, Gretchen's completed 16 hours, the Sunrise Treatment Center leaving 24 hours.
That's community service.
Oh, that's community service through their programming.
Yeah.
Community service.
Okay. Well, I'm not sure
I haven't even seen that.
Okay.
I thought that was some sort of treatment hours that she.
Oh, I've been there the whole time.
I think we.
She's in transitional.
Yeah, she's finished the treatment program in terms of that aspect of it. She's in transitional, which I don't think there's a timeline on that other than when she completes transition.
I was able to purchase a car last week. I bought a car. I'm trying to get it legal and pay off my fines.
She has a payment on her fines for today as well.
All right.
We have some old cases, I think, that we're seeing when we see these.
So the possession charge is about a year old. It's exactly a year and a day. Is the state ready to finalize anything on that, or how do you want to proceed? And she's got some other cases pled guilty to and has been sentenced, actually.
given all of that, I think that it is probably an acceptable time to go ahead and finalize this case, and we will nolly that.
Okay, so 22,393, A and B. Be nolly.
She's got another one, CRA 22502.
Yeah, she's got some others that she's already played through. There's also 22,502, which was also felony. That was a possession charge also. That was the next month, so that was July of 2022, so it's approaching a year on that.
Does the state see a reason to treat that separate differently, or just go ahead and nolly those, that as well?
Yeah. We don't oppose that.
Okay, so both 22,393 and 22,502 are nollied in your completing treatment program. She's already pled guilty to 22,1661 and was sentenced on A and B. So that will continue. You've got community service and fines and costs to do. I'll consider the treatment you did in lieu of the dip school. It said that in the entry, if she completed, she didn't have to go to the driver intervention program. So
Thank you, Your Honor.
Thank you.
So I'll give her another review hearing on the OBI. That's what she's going to be working on now.
Okay.
I think it's a good idea for you to continue with whatever follow-up treatment you need.
Yeah.
It's going to be
It's
on
working
you.
for me. I'm going to stay there.
Good. So I'll set this for July 31st as your next review, and that'll be on the OBI.
And that'll be on the 9 o'clock review docket?
Yes.
Thank you.
You're welcome.
Thank you.
Congratulations.
Thank you.
We look at the details on 22,390, so I need to change the section number and the F2 to the F5.
It's already amended. So
It's already been amended.
we'll just go up to the top and put F5.
Okay.
And it's knowledge anyway.
State of Ohio versus Timmy Bowman, case number CRA 23230.
Mr. DeWater's case, preliminary hearing and pre-trial.
It is, Judge. I talked to Mr. Hield about this. There is an issue I've asked him to look into that involves whether or not the elements of the offense charge can actually be proven. I don't think they can in this situation. But anyway, Mr. Hield suggested to me he was going to look into that, but we need to come back on a different day. I'm going to be back on the 26th if you have room on the docket that day.
That's fine, June 26th. June 26th, preliminary hearing and pre-trial.
Call me, I will.
State of Ohio versus Taylor Farmer, case number CRA 23189 A and B, CRB 23191.
Madam Clerk, Judge, here's your
Yes.
Your Honor, Mr. Farmer has been in residential treatment now for about 2.5 months. My understanding is she's doing well. We met with the QRT team this morning, and they have accepted Ms. Parmenter into their program. So I think the state's intention is, with respect to the possession charge, to nollie it today to QRT. But Ms. Parmenter also has a charge of endangering children, and I believe Mr. Hield wants that to be adjudicated here in this court, which is fine with Ms. Parmenter. She's prepared to enter a no contest plea today with with stipulation to fact sufficient for a guilty finding in that case. And that should conclude this matter as far as this court goes.
So that would be 23-191 is the case number for that.
That's going to be Holly.
No, 23-191 she's entering a plea to. And are you ready to go ahead and do sentencing today then?
Yes, I believe so.
What's the state's recommendation?
The state would recommend 30 days in jail suspended, and we want her to continue to be successful in her treatment as part of that, which is going to be monitored by the QRT program. And we'd ask for probation, and we take no position on fines or any other sanctions.
Ms. Parmenter, do you have anything you wish to say?
Do you have anything in addition to that?
No.
Okay, I'll impose a $100 fine, court costs. Was there a particular amount of time to be suspended?
30 days.
30 days. 30 days suspended. She has on an ankle monitor. Is it time to take
Yes,
that?
she does right now too. You were going to take that off, I think, last time, but we decided to wait to make sure she progressed in her treatment a little bit more. She would like to see if you could take that off of her today.
Order the ankle monitor removed. She's to complete treatment at RRC under supervision of QRT. And set this for a review hearing on July 31st. Then the felony is going to be nollied to QRT. So the only review will be on the misdemeanor endangering on July 31st, 9 o'clock. She'll need to go to the probation office.
Okay, thank you, Judge.
Thank you.
Don't leave until you talk to the probation officer. Okay? He's right after. Yeah. Well, I don't know if you have to go back.
Okay.
You may have to go back down there.
Okay, thank you.
I didn't get the date. We'll come back on.
26th.
State of Ohio versus Kimberly Gannon, case number TRC 213329, A and B.
I've got her update, Judge. You have her. Judge, this is one that was on for sentencing today. We had discussed at Ms. Gannon's plea quite a long time ago that the state would join in a request to treat this as a first offense for sentencing purposes, but that was going to be conditioned on Ms. Gannon's compliance with treatment. I believe that the report from Bethesda most recently says that she continues to be compliant with treatment and is doing well. So I'm hopeful that we can bring this thing to a conclusion today. My suggestion would be, if we can't conclude it today, to make it a term of her probation that she continue to be compliant with treatment.
What's the state's position?
We have been following this for quite some time, and I know that Ms. Gannon has had her struggles, but apparently she's doing a lot better. We don't have a problem with, and we did suggest at the time of her plea that if she were successful in treatment, that it would help us make a determination about what we thought that the recommendation of the court should be. And she has made substantial efforts. And so we are, if she's going to be on probation and continue to be monitored through Bethesda, then we don't have a problem at this point in asking the court to treat this as a first offense and take into consideration all of the counseling efforts that she's gone through and the recovery that she's shown.
Okay, Ms. Gannon, anything you wish to say?
Just thank you for giving me a chance and sending me to Bethesda. I really enjoy it. I like them. I like that program a lot.
Okay, glad it's helping you.
Even when I'm done with this, I think I'm gonna continue, if it's okay with them, just to keep going.
Okay, I'll impose a $400 fine for the OBI, where you pay the court costs, 6-month license suspension, which is already up, 20 days in jail, all suspended, 5 days community service. I'll delete the requirement of you going to a driver intervention program, because you've already done an extensive amount of counseling already, a lot more than what you would get in a 3-day program. I say do follow-up treatment as needed, so I'm going to leave it up to you and Taylor to decide what you need, but I think it would be a good idea if you continued in some follow-up treatment. You say you're going to do that anyway. And I'll set review hearing date for September, let's see, actually that would be, let's back it up. Let's see here soon. Let's make it August the 4th. August 4th will be your first review hearing date. And turn signal violation, $10 fine.
Thank you, Judge.
Thank you.
See Mr. Major in the probation.
I'll take it down there. Thank you, Judge.
You're welcome.
State of Ohio versus James C. Thompson, case number CRA 23306, A and B. Check in.
It is, Judge. He was at St. Mary's last week. I got confirmation. He had a heart attack and was awaiting installation of a pacemaker. I've tried to confirm with St. Mary's that he's still there or unable to appear today, but I would assume so, as it was Wednesday when they sent me the fax, he was still a patient.
Want to continue it?
If we could, Judge, yeah, I'm looking at the report now.
The 30th?
Yes, that'd be fine. In fact, talks about the hospital in here. Okay. Yes, sir.
All right, finished request, case is continued to June 30th.
Thank you, Judge. I'll contact him. Appreciate it.
State of Ohio versus Beverly M. Hines, case number TRC 23182, TRC 222783, A and B. Beverly Hines.
You mean Brandy?
Mr. Morford's case?
Brandy and
It's Brandy.
Brandy. Armstead.
$23,182 and $22,2783.
I'm good.
If we're gonna sit some, it's only this one
Okay.
I'm doing a patient now at Mahajin.
Judge, she's at Mahajin now. I don't know if you've received a report. She did not bring one
Got
with
one
her.
faxed
first.
One is faxed, been faxed, she says.
I've got a report June 1st, that's good.
Not yet. Yeah, I'm going. I'm supposed to. Yeah, tomorrow's my 30-day serving day.
So she's continuing with treatment at Mahajin, looks like.
Yes.
Yes, Judge, tomorrow is day 30 of sobriety. She's relatively early into this. She's indicated she would like to continue at Mahajin. She feels like she's getting herself back.
Okay. So it sounds like continue to monitor if they have any objection to that.
We don't object to that here.
July 14th?
I have a trial common pleas, Your Honor.
July 21st?
I'm here.
Yeah, cases set for sentencing July 21st. Both matters on July 21st.
Thank you. Thank you.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Trevor Fitzpatrick, case number CRB 23-232A and B. TRC 23-379A and B.
Your Honor, Mr. Fitzpatrick was originally scheduled for the 16th, but I'm unavailable for that date now, so I asked him to come in today. This is for sentencing. I believe that to this point, I do have a update on his treatment. If I may. Not yet. He's also completed, I think, 12 hours of community service since we're last here in court.
So you're going to continue the 16th date, is that correct?
Yes, Your Honor, I'd like to continue it that way. Maybe come back in another 30 days, see how he's doing with it. I believe he's going to be doing some more community service. This is based off he pled on 2 OVIs last summer here. Also, he's staying locally. He was going to be working out of town, but he's now working here. He wanted to get this done before he took a job somewhere else out of town. But his mother's his transportation. I believe she's got some medical treatments that she will be going to. And so they're asking for driving privileges for him to go to work and treatment and do his community service.
Mr. Hill?
Do you have an objection?
We don't object to that.
I've prepared an order, Your Honor, if that's...
Okay. Come back July 14th?
That's fine, Your Honor.
All right, next hearing will be a sentencing on July 14th.
Your Honor, he did do some community service already.
Yes. Good. Okay, that's a Friday. Friday, July 14th will be the next hearing.
Thank you, Your Honor.
State of Ohio recalls for order, Abbey, case number CRB 23270, A and B.
Mr. Morford's case for pre-trial.
So I've reached out to Children's Services, and I just now got a response back from one of the caseworkers who's involved in it, wanting to know what I needed to know. It's my understanding that one of the issues has to do with the child who's 17 years old, almost 18 years old, is with the family of a friend of hers. And it's our understanding that she doesn't want to have any contact with her mother at this point in time, but that the people that are keeping the child need to have a power of attorney so that they can get medical care for the child if it would become necessary, not that there's anything now. Our intention is to allow this to go on for a while, and then with a dismissal if there aren't any further problems, which it doesn't look like they're going to be. So that's what we would be intending to do at this time. But we need to...
They need a medical power of attorney.
Need a medical power of attorney, and I'm also, I'm getting an answer right now from the caseworker to make sure that there aren't any other problems.
Judge, I'm a little puzzled as to the need for a medical power of attorney. If Children's Services stepped in and has taken custody of these children,
They don't have custody. They just place the child with the friends.
With the girlfriend's parents.
Yeah.
So there's no official taking of custody, no legal documents.
Right.
apparently not.
Does she have any calls about giving them a medical power of attorney so they can make medical decisions?
No,
Hopefully
sir.
it doesn't come to that.
No, but we would like, there's occasion to use that Ms. Abbey be notified by the caretakers, I guess, to be the proper term, of her daughter right now. I think that's the only.
Seems reasonable to me. And the child is 17 something, so I mean,
Yes.
she's gonna be, it's a female, right?
Yes.
She's gonna be 18 pretty soon anyway, that's gonna cure that, she'll be able to make her own.
Yes.
Medical decisions after that, so.
I just want to make sure that she's okay. She's already been threatened to get kicked out of that home twice already, and there's nothing that I can do. I don't know what to do for her, or
She's been threatened to what now?
to be kicked out of that home
Oh,
twice
be kicked
already.
out, okay.
Do you have an attorney in the Children's Services case?
There's a gentleman I've been talking to with CPS.
He was answering, but didn't complete the message or whatever. I don't know what's going on there.
I just want her to be safe. I'll do anything anything that you want me to do. I just want my baby girl back home. Any programs, therapy, whatever it is it takes.
Are you doing something with Children's Services now, or they got you into some sort of program, or?
No, they were waiting to see what the court said.
Oh.
But I spoke with my lawyer here, and I told him that if it's therapy or whatever it is that needs to be taking place, I'm willing to.
When did she turn 18?
October 6th.
Okay. Is she out in school, out of school, or what?
It's summertime right now. She's out of school.
Well, I know that, but I mean, is she gonna be in school? Is she graduated, or is she gonna be back in school?
She'll be back in school.
I think that it might not be a bad idea if we arrange to have her here at a hearing in the not-too-distant future, see if we can't come to some agreement and understanding of things.
Agreed.
Agreed.
How about the 30th, June 30th?
Is that on a Monday, sir?
It's on a Friday.
I work on Fridays.
Okay, we can make it on a Monday. July 3rd is a Monday.
Okay. Thank you.
July what day?
3rd.
3rd. I'm here, Judge.
All right, let's set it for July 3rd and try to get her here for that hearing. I guess work through children's services to.
Well, we shouldn't, I mean, they're not officially involved, they just kind of facilitated the process, so we'll get her here one way or
The
the other.
charges for domestic violence.
State of Ohio recalls Cameron Weaver, case number CRB 23284.
Mr. Steyer's case.
We were able, Your Honor, to make contact with school authorities who were agreeable to the idea of Mr. Weaver doing some community service and then coming back, and we would dismiss the charge against him if he successfully did that. We'd ask for 5 days community service.
And I've discussed that with him. He's agreeable to do that. We just need to get a date back. I would ask for the 30th or the 3rd or the 7th to give some time to get that done, and I'm going to be out of town next week.
Well, the 3rd would be 3 weeks. I think that's a pretty reasonable time.
That does seem reasonable, Your Honor.
July 3rd would be the next hearing.
And is there anything we need to do to arrange that with you beyond just the normal?
Talk to Mr. Cooper. He's going to come to do 5
10
days
o'clock.
community service.
Okay.
There's no order for it.
Okay.
Have him here when we draft that.
State of Ohio versus Damian Fox at the
Thank you.
Lawrence County Jail on a recall, case number CRB 23307, A and B.
Damian Fox. Mr. Wilford, we're going to try to get some more information on that.
Judge, I've spoken to my client. I've also spoken to Officer Preston of the Adult Parole Authority. He was going to interview the defendant's family at noon and then staff the matter with his supervisor, Matt Stunteback. He believes that his department will be on board with him being released to inpatient mental health treatment.
When do you think we'll know that?
That, I don't know, Judge. The interview with the family was supposed to take place at noon. He was to call me back as soon as he'd seen them and staffed us with Stunteback. He did not give me indication when that staffing might take place, Your Honor.
Well, why don't we do this? Why don't we put it on the docket for the 16th? If you can reach an agreement that he go someplace before then, we can do it by entry before the 16th.
I think that'd be the best way to proceed, Judge. Now, I know probably what he's going to ask the judge, and that's going to depend probably on answer from the Adult Parole Authority. He's wanting to know if he were to go to inpatient treatment with a monitor, if that time would come off the time that he owes the Adult Parole Authority.
Oh, well, I don't have an answer for that. You have to ask them.
That's what I told him I'd ask.
That was a question, but the question is, if I got to wait another week and a half, the same way I can get out and get, I got relief from here and went to St. Anne's Hospital, and I was on a ventilator and everything, and then I get released from the hospital, and I come straight over here, and they arrest me for having a domestic violence charges, the parole board people. Is there any way that I can get home and on an ankle monitor, go on an ankle monitor?
No, because you have a holder from Adult Parole Authority. It's not my holder. I'm not the one holding you. They are. So I can't override what they do. They've got a holder on you. It's not my jurisdiction to say you've got to release him anyway, even though Parole Authority does. So we're working on it to try to get. So the answer is no. You can't be released until they agree that you can be released.
Damien, I'm trying to work on that as quick as I can, but it's not just in my hands and the court's hands. Your parole officer has to take some action, interview your family, then he has to speak to his boss. He and his boss are going to make a determination as to whether or not they feel they have enough evidence to return you to prison, or if they're agreeable to you going to inpatient treatment.
I know that, sir. All I was trying to say was, if I go ahead and take care of Judge Cameron stuff, I don't have, the parole board only has 10 days to make a move. Like, I'm almost going to sit here 10 days on dead time. Then I'm going to sit here for the 16th, and then it's going to take another 10 to 20 days until they're ready to make a decision. And that's almost over a month that I was sitting on dead time.
Mr. Fox,
So I was trying to get...
I was told that decision will be made probably today. Your parole officer is working on it right now. I understand you want to be released right now, but unfortunately, I don't have a magic wand, and there are other people involved in the equation that have a say-so. Judge Capper is not standing in the way of you going to mental health treatment. I have to get that cleared through your PO first.
Yes, sir.
So if they clear it before Friday, I'll sign an order if both your attorney and the prosecutor can agree on one. They send me an order releasing you to treatment, I'll release you before Friday. If not, you're back on the docket for Friday and we'll address it then. So hopefully it'll get resolved this week.
Your Honor, one other thing that we would ask as a requirement before he get released is that he would sign that protection order.
Okay.
And at this time, both of the parties that are the alleged victims want the protection order. Hopefully won't be permanent, but for right now, we need him to sign that.
I'm going to send down a protection order for you to execute involving Tayshawn Fox and Renee Fox.
That's who my parole officer want to talk to. That's who I live with. That's my mother and my sister's son. They're the one that my parole officer is having an interview with right now. They just want to get treatment. Like, I live there, but that's the only place I have to lay my head at my mother. And my nephew lives at my mother's. And me and my mother didn't even have a problem. It was just me and my nephew. And I blamed my nephew. I shouldn't have been doing what I was doing. But I can't sign a protection order against someone that's the only place I have to lay my head.
Well,
And my mother doesn't want me.
but you're going to be going to treatment, hopefully. That's where you're going to be. You're not going to be with them.
When they come to us and say we don't need the protection order anymore, then we'll ask
They
the
can
court to
withdraw
dismiss
their
it.
request for protection order if that's what they want. Okay, as of now, it's June 16th.
Thanks, Your Honor.
State of Ohio versus Eric L. Summers, case number CRB 2372, TRC 21, 1980, A and B.
Butch.
This is Mr. Smith.
It is, Judge. I called Mr. Summers, spoke to him at the jail. We cut it a little bit short because I had to come back in the courtroom, but it's my understanding he has been in jail now for, since yesterday, 24 hours on the carry-tip here. As I look at the court file, it appears he's done his community service. He's down to $131 that he owes in fines or cost, I'm not sure.
And there's a Walmart theft.
And the Walmart, he is willing to enter a plea to that, hopefully resolve it today. I think the state would recommend the standard Walmart-type penalty, and if so, he's willing to go ahead and, if the state offers that, he would enter a guilty plea.
Well, I think he's got 2 days in jail.
1 or 2?
He's got one back in January.
Oh, yeah.
And another one, I guess, this time around. So as we would suggest, Your Honor, that maybe that would be part of the disposition, that the fact that he's actually done 2 days in jail might satisfy something else.
Okay. Mr. Summers, do you agree with your attorney? Do you have anything you want to tell me? Okay, on the Walmart theft, which is $23.72, I'll impose a $100 fine, court costs, 10 days in jail, suspend 8, give you credit for 2 you've already served, or you can do 5 days community service and stay out of Walmart, and have a review hearing. He still has a fine he hasn't paid totally off.
It's 131, if I've read that right.
Yeah.
I think
So I'll set everything for a review hearing August the 11th. Second Friday in August. You gotta come in at 9 a.m. Unless you've got everything finished. You get it all finished, you don't have to come in. Okay, you're gonna get out of jail today.
Thank you, Judge.
Court's adjourned.
The one underneath is the destruction thing.
I think this one seemed longer than Friday. I think it's just because I've been feeling good. Right?
So it's a lot more confusing than Friday.
Did you have a big what there, Mr. Romero, you said?
Yeah. Okay, you can bring him back. Back to the office.
People waiting up there to get married.
Who's getting ready to perform a marriage?
Yes.
Hey, Dorothy.
Yeah.
I left my, thing.
Here.
Sarah, I got that. Jump.
Oh, thank you. I was gonna, I'm glad you remembered to grab that.
Okay. Need me for anything else?
This isn't the right one.
Yeah, it is.
No, I don't think it is.
Yeah, it is. The little lid on it is at my house.
The little lid is at your house? Is that right? The
Yeah,
same?
that's not one
It
of those
looks
ones.
wrong.
It's the one.
I thought it was I've had a 16 gigabyte one. Are you sure this is right?
Well, it was in the machine.
But maybe it's for something else.
I don't know. I don't think so.
No, I don't think this is.
It's right where I left it.
I'm gonna play with my computer and make sure.
Okay. Pretty sure it is.
Check. It just doesn't look familiar.
Okay, so. You need me for anything else?
I think I'm good. Thank you, though. Figure out these other people, these mystery people.
I got a huge set of text messages from the caseworker on that Abby case.
What'd he say?
So much I couldn't read it.
Okay.
I'm going
Fair.
to take it home and print it, I guess.
Joy.
I'll send it to you.
Oh, okay, thank you. I was gonna tell you that Jose Umana, Jasmine has a file, it's gonna be in Ireton, but, Brian filed a motion to suppress on it. And I sent it to you, but I also stuck it down in the file too, in case you wanna. Yeah, and that Russell Daniels, I think, too, he did one on that too, but it's in the file also, so.
Super.
I know, you're so thrilled, aren't you? Yeah.
I think that, well, at least I don't think they're really doing it just for fun anymore.
Right, well, especially Tyler Haslund, I'd say. Well, it's kind of annoying that you had to disprove everything he said, but I mean, you did a good job of it.
All the stuff about, all the Ohio Department of Health records.
Oh, yeah.
I figured out I don't need those if they don't say something specific.
Right.
So.
And Brian has gotten really good about being very specific, I feel like, with his, so.
Yeah. So that's all.
Yeah, see ya Friday.
Okay.
All right.